NBC's Julia Ainsley is at the DOJ with the latest for us. Also with us, former Assistant Director for Counterintelligence at the FBI and MSNBC National Security Analyst Frank Figliuzzi, and former U.S. Attorney and MSNBC legal analyst Joyce. Vance, Ari Melber, Andrew Weissman still here with us. So, Julia, we know Attorney General Merrick Garland has been quiet about this case. Jack Smith has been very quiet. A few days ago, we caught up with him with a camera. He didn't look at the camera. He didn't respond to questions. But what more can you tell us about him or any possibility that we may hear from him or Merrick Garland?
Well, I can tell you that the position that Jack Smith and Merrick Garland are in today is the fact that they are already seeing Trump control the narrative. It's really similar to what we saw out of those state charges in New York, where he is already going out, even though it's a sealed indictment, he's going out saying all of this is a hoax. Meanwhile, Garland, who we know has been briefed on these charges and briefed along the way, and then Smith, of course, who is the prosecutor bringing these as special counsel, we know that they are now in the tight position of trying to decide what they can say before the narrative gets away from them without trying to step on their own toes, since that indictment remains sealed. They want to follow those rules. But at this point, we understand that Garland will not play a role in the decision to unseal that indictment before the arraignment. They can unseal it at any time, but we know that Garland won't play that role. That decision will come from Jack Smith. And because the indictment may include some sensitive information, they are discussing, of course, classified documents. If they need to talk or summarize any of the material in those classified documents, they're going to need to be very careful in how they do that, perhaps needing to do some redactions and notify people who may be named. That could take more time. So that's the position the Justice Department and Jack Smith finds themselves in today. Can they tell the public more about what the former president has been indicted on without going forward and breaking some of their own rules, appearing political, or breaking those rules about that seal? But what thing we can be sure about is we won't hear from them until that indictment is unsealed and those boxes are checked.
And Joyce, let's talk about the judge assigned to this case, the Trump appointee, which is not the relevant issue, but it's Judge Aileen M. She initially oversaw, as you know, the handling of the classified documents after the Mar-a-Lago search and delayed the prosecution for months with decisions that favored Donald Trump and were eventually decisively overturned by the 11th Circuit. So what do you make of the fact that at least initially she's going to be overseeing this case and initially hearing motions to dismiss?
So it's not entirely clear yet the role that's been assigned to Judge Cannon. If she is in the mix for arraignment purposes, that's perfunctory. That's a routine proceeding that judges perform day in and day out. But if she is, in fact, assigned to this case as the trial judge, there will be serious questions about whether she has behaved in a way in the course of the Mar-a-Lago search warrant proceedings that so undermines public confidence in her objectivity that she needs to step aside from this case. I think we'll have to wait till we see what her status is to see whether she decides to voluntarily recuse or whether the parties, most likely the Justice Department here, might ask her to step aside, and then what will follow from that request.
I mean, I really want to talk, guys, about the Subway sandwich that Jack Smith was carrying as he went back to his office and really discuss his choice of dietary
That's
options.
why he didn't want to talk. He wanted to eat.
That's trouble, so. Katie, talking that way. That's trouble.
I know there are better options on that street. But I do want to ask you, Frank Figliuzzi, about just this nearly 24-hour, not quite, black hole that the Justice Department, that Jack Smith has left for Donald Trump and his team to fill, about the allegations, about the indictment, about what the charges might be. Was it a mistake to not unseal it the second they told Donald Trump's lawyers that he was indicted?
So I'm looking at things through the security perspective here and the threat and risk picture that's developing. And if I answer that way, I would say yes, because it's given everyone on the Trump side an opportunity, including all night last night on a certain other network, and people like Senators Tuberville and Hawley and Speaker McCarthy and everyone else saying this is the end of democracy. This is unfair. He's being targeted. This is all about Biden, Biden, Biden. And so do I expect that naively to disappear, of course, when and if this indictment is unsealed? No, but if there is damning information, and there likely is in here, that lays out what is likely to be horrific conduct by the former president, it's possible that it would have a mitigating effect on the incitement of anger and potential violence, and that it would cause those people to hit the pause button because they're about to embarrass themselves not having understood the indictment.
Yeah, it didn't take long, Joyce, for the former president to come out. He released a video last night claiming his innocence and warfare for the law. And he said, quote, "We cannot let it happen." How much of this case do you think is going to be fought in the court of public opinion? And obviously, there's one thing about what the political ramifications are, but for jury selection as well.
So when it comes to Trump, everything goes to the court of public opinion, and never so much as when he's on the campaign trail. I think that's just baked into this landscape. You know, a judge may try to rein him in if for no other reason than to preserve the ability to select an impartial jury. But ultimately, you don't want to do anything here that could give rise to some form of a First Amendment prior restraint issue on appeal, or interfere with the campaign. It's unprecedented. I don't know how many times we've all used that word recently, but that's just the reality here. But, you know, that said, every time Trump goes out and makes a public statement, it's a double-edged sword, because so frequently it just adds to the evidence that's available to prosecutors in this or other cases against him. The more he pursues his defense in public, the more likely he is to add to the weight of the evidence against him.
Let's talk about the squishiness. Is there any squishiness, Andrew, in this case? Is there any, what's the, I guess, the vulnerability for the prosecution, the big vulnerability that they have?
That's a great question, and that just, that's what every prosecutor focuses on before they bring a case. And when you write a pros memo for your supervisor, and when you're looking at a pros memo, you focus on that. What are the defenses? What are the responses? And is it not just can you make the case, but should you? So here, not to sound partisan, I think that the squishiness in this case is the judge who gets assigned. That's, in other words, that's not the facts or the law. That's a question of, are you going to be in the same situation you were in with respect to the special master appointment, to having the case stayed essentially during an investigation, unheard of, and having to go to the Court of Appeals not once but twice to get the judge reversed. With respect to as I said, the obstruction part of this case, it remains to be seen exactly what the evidence is, and I think we'll get a speaking indictment that will tell us a lot of what the government intends. It is really hard to see how that is defensible. That is the reason that in the vast, vast majority of these types of cases, the person pleads. You've got many examples of senior people, from David Petraeus, Sandy Berger, John Deutsch, who all admitted what they did, and they actually get a lighter sentence because of that, because these are very hard cases to defend. And I think it's very hard to sort of figure out what is a plausible defense here.
And Andrew, is there another aspect here, not just the judge in this case, and this one is controversial among lawyers at least, but the fact that in Florida, you do not have judges with as much experience in handling classified documents, and you've got a political calendar clock here that's running against the prosecution, for sure, in favor of Donald Trump, as you get closer and closer to real voting. As we say, January is the first caucus and primaries for Republicans. So, what do they do with that? Because all of these documents have to be so carefully vetted, and the crucial decisions have to be made by multiple agencies in the intelligence community. And just getting them into evidence is going to be hard.
So that is just such a great question. I was thinking about, if I were still at the department, the conversation beforehand about where to bring the case.
Right.
One of the key things that you would be saying is that would favor D.C. is that in D.C., the judges deal with classified information so much more. It doesn't mean that the judge hasn't dealt with it, at least to some extent in Florida. It doesn't mean that a judge who's never dealt with it can't get up to speed. But SEPA, that statute, is very complicated. It is really useful to have a judge who has been through the ropes and knows how to deal with that. That, to me, is one of the biggest impediments to time. In terms of getting this case to trial, is going through that SEPA procedure.
Yeah.